The Sarasota County Bar Association is a proud partner in bringing you Law and Sarasota. With voluntary membership of over 900 lawyers and judges, the Sarasota County Bar Association is your community's leader in advancing legal professionalism, practice development, and public service. Visit www.sarasotabar.com for more information and to use the online directory list to find an attorney.
This program is brought to you by a grant from the Community Foundation of Sarasota County and the Sarasota County Bar Association. The Education Channel produces the program and broadcasts from its state-of-the-art campus on Beneva Road. They make this program possible.
Welcome to Law and Sarasota. This is a special program dedicated to understanding how the local courts are dealing with the challenges of the pandemic. In response to the threat posed by COVID-19, the Chief Justice of the Florida Supreme Court, together with the Governor, started issuing emergency orders in March. For the judiciary, this meant severe restrictions across the board for the range of cases that daily fill our courthouse. This imposed significant leadership and logistical responsibilities on the chief judges in each of our state's 20 circuits. They serve as the administrative supervisors of court activity in their respective circuit. Here in the 12th Circuit, this means the chief judge has to accommodate the unique circumstances of 3 counties, Sarasota, Manatee, and DeSoto. The primary consideration for the chief judge is to make sure protective measures are in place for litigants, witnesses, staff, and court personnel. Yet all court activities could not simply come to a screeching halt. There are critical services essential to the justice system that must continue, despite the presence of an active virus. Adults and delinquent children are arrested and incarcerated and awaiting trial or sentencing. Abused and neglected children are removed from parents. Parents need child support paid. And the progress of trials, both jury and non-jury, civil and criminal, is impacted. We have as a guest today Kimberly Bonner, the 12th Circuit Chief Judge. She's here to discuss how our circuit is coping with the evolving exigencies of the pandemic and how to let our viewers know what steps have been taken to allow essential court activities to function. Welcome, Judge Bonner.
Thank you for having me.
Let's go back to the beginning. It's March. You're conducting your normal activities, and then something happens with the Supreme Court. Tell me how this thing started and how you responded.
In about mid-March, when the pandemic was starting to really gain a lot more attention locally and raise concerns, we were all aware of and watching the situation and making our own plans. But then in between Friday and Monday, the Supreme Court did come out with some administrative orders that essentially halted many things, including jury trials and some other court functions. And so essentially we had about Saturday, Sunday, and Monday to start making preparations for how we were going to continue operations.
Now, this was unprecedented. There was no template for this happening in the history of our state, really.
No, and you know, ironically, we were very prepared and have been and still are very prepared to deal with any number of emergencies, being obviously an area that's prone to hurricanes and other natural disasters. We are very well equipped to deal with how to deal with those kinds of emergencies when the power goes out or a roof gets blown off or the windows break or something like that. And we did have, ironically, a pandemic bench guide that had been prepared less than a year before. That bench guide, however, really dealt more with the legal issues that come up when you have things like quarantine orders or isolation orders being violated, you know, legal issues and not necessarily the logistics of how do you conduct court when there's a pandemic. So it was unprecedented for us not to have to deal with something that was in the nature of maybe we just need a few portables to have court because the facility is damaged versus we cannot have more than 10 people in a room at the same time. So that was definitely unprecedented for us.
So it was broken into phases, and you were into what, phase 1?
Right. What the Supreme Court did early on was to establish a statewide work group on the continuity of operations, and it was based on 4 phases, and the work group in part being tasked with setting benchmarks for how to go from phase to phase. And there are 4 of them for the courts, which is, I think, important for people to distinguish the difference between the courts phases and what they see happening statewide, because the governor set out statewide reopening, and we have been in different phases of that. Our court phases operate independently from that because court operations fall under the Supreme Court. So although they might see where we, for example, are in phase 2 in Sarasota and Manatee County, the state might be in a different phase. It's because they are for different purposes and based on different benchmarks. So it's based on the phases 1 through 4, 1 being where we started, the most limited. Courts are essentially shuttered as far as physical in-person proceedings. And then phase 4, which we are hoping to get to, phase 4 is when we essentially reopen completely with no restrictions.
So Judge Bonner, tell me, what were the most significant changes that you had to make right off the bat?
Right off the bat, we had to make changes to the types of hearings that were being done in person to limit the foot traffic within the courthouse, which required us to get a lot of judges and staff up to speed very quickly on the remote technology that we were using for that, and to educate our litigants, the lawyers, and the public about how these hearings were going to be conducted. And then secondarily, to make sure that we were scheduling and staffing ourselves in a way that would cut down on the likelihood of us inadvertently passing the virus to each other. So it involved staggering work schedules and distancing ourselves, as well as taking protective measures so that one entire department wouldn't go down if somebody did end up testing positive.
Well, some of the traditional rules that govern court operations changed, and one that came to mind to me was with delinquent children. We were forbidden by court order from doing that remotely. We actually had to bring the children into the courtroom, and we could not do it by TV or telephone. And one of the things that changed, as I understand it, was that we were now allowed to do a wide range of types of cases remotely where we didn't do that before. Let's talk about how it impacted the felony bench, which is where a lot of activity occurs. You've got a lot of due process issues there with people incarcerated or getting arrested and want to get out, want to get sentenced. How was that handled?
It was handled very efficiently, I think, and very promptly by both our Chief Justice and locally our 3 administrative judges for our 3 counties, Judge Hall, Judge Roberts, and Judge Moreland. And because the Chief Justice suspended certain rules of procedure temporarily to allow for things to be done by video or using other technology that might otherwise not have been done, we were able to, for example, have people resolve their cases, particularly if they were in custody and they would be able to be out of custody by resolving their case, instead of waiting until transport to the courthouse resumed. And so we were able to set up multiple jail feeds, and through a collaboration with the Sheriff's Office command staff and our IT, who both did just an amazing job early on getting us set up with having those multiple jail feeds. But for that, we would have been still even more months behind now. So we were able to get up to speed and running full dockets very efficiently, having people resolve their cases, have their cases heard, have them resolved, even cases that involved inmates that were being held on behalf of other counties, whether it be within our circuit or out of our circuit. The Supreme Court did set up procedures where we can resolve those cases by communicating with the other county, by communicating with the attorneys and the judge assigned, so that, for example, if we have somebody on a Sarasota charge who's being held in Leon County, or if we are holding an inmate from Hillsborough County, we can still address their cases. They might still be able to have them resolved, because what happened is They suspended transport of prisoners both between counties and between DOC, Department of Corrections, and the counties for quite some time. And we knew that that was going to be the case. And so we got an early jump on that by setting up a process so that people would not be languishing, not having their cases addressed simply because they were not physically coming to a courthouse.
Well, I understand there's also a moratorium on all jury trials.
There is at the moment for those counties that are still in what we call phase one, and phase one is where we were basically in March when everything happened. When a county can go to phase two by meeting all the necessary benchmarks, they will be permitted to begin jury trials, although being in phase two still requires us to socially distance and to wear protective equipment and to have a temperature check to be able to get into the building. This means as a practical matter that we can summon fewer jurors, and we have fewer spaces that can accommodate jurors sitting 6 feet apart. Many of our courtrooms are quite small. Our jury boxes and jury deliberation rooms are quite small. So it does substantially reduce the number of jury trials that we can do, but we are still permitted to begin that process.
And I take it that you're going to give priority first to the criminal cases?
Correct. We, as part of the work group activities, one thing that we did was prioritize essentially which cases go first when we open back up. And as you mentioned, there are certain what we call due process or mission critical, mission essential cases that will always be first in line. And those include, as you said, people who have been arrested and are entitled to a bond hearing within 24 hours, when children are removed based on allegations of abuse or neglect, when juveniles are arrested, domestic violence cases where people are entitled to have their return hearing in person. So the first case in the door, so to speak, will be criminal cases as far as resumption of jury trials.
I understand that the civil judges are conducting non-jury cases and evidentiary hearings remotely too. How do they handle things like presentation of evidence? And I know the Supreme Court has now allowed judges to administer an oath remotely. It used to be you had to have a notary public in the location of the witness to swear the person in, and then they could proceed. But without that, or a stipulation, it could not go forward. But now they've relaxed that now, so judges can actually administer the oath? That's correct.
And that was one of several rules that the Chief Justice did suspend. The intent of that, for example, administering a witness oath is obviously to make sure that you are speaking with the person that claims to be the person that's the witness or on the docket. And we would normally have required them to be in the presence of a notary unless they are with us physically in court. By relaxing that rule, it still requires us to make sure that that person's identity is authenticated. And sometimes it is an attorney saying, I know that is my client, or, for example, I'm in a family division, and I might often have one litigant that says, I recognize that's my former spouse on the, on the video or on the phone. So by relaxing and suspending those procedural requirements, it allowed us to very quickly get our dockets back up and running. And I'm in a family division, for example, and the civil judges as well are able to do multi-day trials. We are able to look at evidence through a share screen function for those of us that are using the Zoom platform, which is pretty much most of us. We have set up practices and protocols that tell people how to plan ahead of time to make sure that they are sharing those documents and not trying to hold them up to a screen for everybody to see. And it is, I wouldn't say it's without challenge, but it certainly has allowed us to get up to, I would estimate, at about 80% capacity in those divisions that don't have a large need for jury trials. So the biggest hit as far as backlogs will be in the criminal division, where the jury trials haven't been going forward since March.
Before the pandemic, in a trial, the attorneys are present with their exhibits in the courtroom, and they would present them in person to the witness and ask for identification and authentication and go through their evidentiary requirements for the admissibility. How do you handle that remotely?
What we do is, because we are not entirely paperless, we are in an aspirational way paperless, but There's a few different ways that can be done, and different judges have slightly different procedures, and the work group did put out a lot of product on best practices for handling evidence remotely. So, for example, they can be pre-marked and provided in an electronic format to the other side and to the court. They still need to physically get to the clerk of court. So sometimes a party will file them with the clerk of court in that fashion, and we will then have to determine in a different paper or order which of those have been formally admitted. I also have attorneys who are still sending exhibits and things in paper, which is fine. They are marked exactly as they would be by myself or a clerk if I'm with a clerk, and then immediately forwarded to the clerk of court for filing.
You know, one of the positive things about doing that process remotely, it requires the lawyers to get their act together before the trial. I mean, I can tell you, having tried many of them, that sometimes they walk in there, the first time they've seen the exhibits is when they walk in the courtroom, and this forces them to get organized and have their case ready to go a couple of days before, so the exhibit package is complete and they've seen the other side's package.
And the other benefit as well is it forces them to make sure that both the other side as well as their client has that particular exhibit in some way, whether they email it to them or send it to them. Because we've all learned through trial and error and the hard way that it's not very effective to hold up a piece of paper to the screen on your on your computer and say, can you see my exhibit A, to a witness who may be 3,000 miles away. And oftentimes the attorneys and their clients are not physically in the same space. And so it has had a lot of benefits that we found, which is that advanced preparation makes it a lot easier to ensure that everybody has the same information for trial ahead of time.
Well, our courtrooms are public, except for certain limited types of cases. How do you ensure the public has access to these proceedings when they're remote?
One thing that I've been very concerned about and very attuned to is the need to make sure that the public knows, first of all, that we are open for business, just in a different fashion, that we are working, and that court is still an open court, both to the media, to members of the public. And so we have taken great efforts to make sure that our website reflects that for those judges that are, for example, doing their hearings by Zoom, that the public has the information on how they can observe those hearings, assuming they're not, as you said, proceedings that might be confidential, such as certain dependency cases or adoption cases. And that is, again, not without challenge as well, using that platform. For those few cases and types of hearings that are being done in person, we try to accommodate anybody who wants to come in as an observer. With social distancing, you may just have to wait until there's an empty spot. But just as you would before March, the public is entitled to come in and watch what we are doing, and we encourage them to do that.
Well, let's have you describe, if a person comes to the courthouse, as they approach the front, what are they going to see? What are they going to go through? Let's assume that they're a witness or a litigant and they have a right to be in a courtroom. What would be the process for their admission?
The process is going to be the same in all of our locations, and that will be DeSoto, Manatee, and Sarasota in our circuit. So there will be screening stations outside. They will be asked a series of 5 questions that are the standard questions that do get amended from time to time by the CDC based on COVID exposure. For example, are you awaiting test results based on symptoms? Have you been exposed to someone who's tested positive, et cetera? So there's those questions. Assuming that they answer no to all of those, they are then given a temperature screen. In some locations, we actually have an apparatus that does that, and in some locations, we have people that physically will take a no-touch temperature. And then we obviously double check to make sure that the case that they are there to observe or to see is actually on the docket and going forward. And then they are admitted. So it is a little more time consuming, a little different, but it is essentially the same thing that you will find when you go into many public buildings or doctor's offices. It is the temperature screen, the questionnaire, and then making sure that what you are there to do is going forward.
So are the judges' dockets online?
They are. And to the extent that an individual docket may not be live updated. Any member of the public who wants to know what's going on in a particular court that day can simply either call that judge's office or call court administration. And court administration does keep a daily list of what every judge has on their docket that particular day.
Well, the circuit court, you've divided into 5 divisions, and we've talked a little bit about felonies and about civil. How's probate running?
Probate's running very well because probate is a practice that tends to be more of what I would call a legal practice than an evidence-based practice. So more often than not, you have attorneys and clients making legal arguments as opposed to long drawn-out proceedings where people may be testifying. So it's really lent itself well to being done remotely because the attorneys have found some of the hearings are relatively brief. And so as with other divisions, they found it is a lot easier to do those remotely than to get in your car, drive to the courthouse, park, come through security, go to the courtroom, wait for your case to be called, have your very brief hearing, get back in your car, drive back to your office. And so a lot of the attorneys have really seen the benefit of managed properly. Doing these cases remotely is actually much more cost effective and time effective for them and their clients.
How about the juvenile division that handles delinquent children as well as dependencies? How have they been impacted?
They have, as you said, juveniles have always been treated as a very unique and special circumstance where we had always been used to and accustomed to having them in person with us. And so their adjustment has also been to using remote technology, but also to make sure that even if there is a remote appearance, that the juveniles, the parents, and their attorneys still have the same ability to confer privately and for a reasonable amount of time as necessary, just as they would if they were in a courthouse. So even though they may be physically separated, we have taken a lot more measures to make sure that the technology is available so that they can have those meaningful private conversations between their parents and their attorneys. And they still are doing many things remotely, but based on the priority of cases, when we are starting to open back up, and we are in phase 2 now in Sarasota and Manatee, one of the first types of cases in line, so to speak, will be those juvenile cases for those things that really need to be done where everybody is together.
Well, we've been talking about the circuit court judges. Let's talk for a few minutes about a county judge situation. And you were for many years a county judge. You've got foreclosures, you've got civil actions there, you got small claims, you got traffic. How's that working?
The county judges have really, really taken up the task and done very well with it because one of the dockets that essentially went away during phase 1 because we were not allowed to have these mass dockets with people sitting elbow to elbow, that impacted the county courts really disproportionately because that meant that they could no longer do those arraignments 4 days a week where you might have 80 to 100 people, and that was just for the morning. So they had to get very quickly accustomed to what can we do remotely, understanding that many of the defendants in county court might not have connectivity, they might not have phones, many of them might have mental health issues or not a stable address, and we did not want to be in the business of issuing warrants for not appearing remotely for somebody who doesn't have a good place to get mail. So they were very quick to come up with processes to make sure that that didn't happen. Small claims is going forward. They are doing mediations remotely. They are doing all of their motion hearings. They have really stepped up. Obviously, the foreclosures and evictions have been abated for many months based on the governor's executive order and then Justice Kennedy's companion orders. And they are ready and prepared to deal with the cases that will start coming back in full force when those abatements are over.
Is it residential foreclosures?
Currently it is. It was the first iteration of the orders did have some very inclusive language that included every form of foreclosure, and then there was some subsequent modifications to it that made it clear that it was residential.
Okay. Now, this entire operation must impact a number of stakeholders. How do you coordinate that? Is there a meeting or a group of folks that meet to try to work this out, and what is it?
Right. In addition to the statewide work group, because that is comprised of all of the stakeholders, offices, constitutional officers. Locally here, I have a weekly call on every Friday at noon with all 3 counties within our circuit, and it's our stakeholder meeting, and we go through every county. And the people on that call include health officials, health officers from all 3 counties, the county administration, clerk of court, sheriffs, as well as the judge's side, public defender, state attorney, regional counsel, and representative for the bar. So we have an update from every county. We go over any issues, concerns. We talk about the phase up, where the numbers are, what our processes are, and everybody has that weekly update so that we know in all 3 counties exactly where we're going, where we've been, and what issues and problems we need to address during the next week.
That's a weekly meeting.
It's a weekly meeting. We've been doing it for quite some time, and it's hard in a circuit that has this large a population to keep everybody informed on kind of a live streaming basis, because the situation can change from hour to hour. But we try our very best to make sure that our website is updated, that we are giving people the information they need, that we are giving the public the information they need, and that the people who are affected by these court cases and the closures are aware of what we're doing and where we're going. So we try our very best to keep everybody informed.
What message would you like to leave with viewers who may be called as jurors, and we certainly need them to come forward, or others who may have a reason to come to our courthouses?
By the time this airs, we will, and we are currently in phase 2, and we hopefully will still be in phase 2, which means that jury trials will start resuming in September. So what a juror can expect, because we understand we are compelling you to come to court. This is not a voluntary trip to the drugstore. So they can expect that our courthouses will have cleaning protocols and sanitation protocols, that everybody will be health screened, temperature checked, and socially distanced, that they will be provided masks if they don't have their own, and that every CDC guideline and local health guideline and recommendation will be followed, so that our buildings and our hearings will be safe.
Okay. Well, that's about all the time we have today. I think you'll agree Judge Bonner is effectively meeting the unique challenges presented by this difficult and unprecedented situation. It's truly a crisis. Judge Bonner, as a rancher, you're more used to herding cattle, but you've been called to steer the courts through this rugged country that we call COVID-19. Thanks for all that you're doing, and we look forward to continued due process operations proceeding in our courts, and thank you for doing all that you're doing.
Thank you for having me.
For more than 36 years, the Community Foundation of Sarasota County has worked one-on-one with estate planning attorneys and their clients to make a lasting impact through philanthropy. Stable, trusted, and knowledgeable, the Community Foundation safeguards the charitable legacies of donors to ensure that they continue for years to come. Visit www.cfsarasota.org or call 955-3000 for more information.